For judgment, item numbers 1 and 2.
Petitions are dismissed.
May I please, Lordship? I beg to mention hearing item number 8. Lordship, here this morning I've got instruction on the petitioner to withdraw the case with liberty to file afresh.
At hearing stage.
Lordship, maybe off the record, Lordship, but then the petitioner, I think they had a meeting with the department yesterday. Since the state responsive adopted the notification, so if she fulfills all the criteria, she will automatically be granted the relief. So
This
that
is what
it was for granting scale of pay.
Oh, okay, scale of pay.
Yes.
So that March notification
Yes.
is there.
So as per, I'm able to withdraw with liberty to file afresh.
Right, item 8 for hearing. The learned counsel for the petitioner as following praise for withdrawal of the petition with liberty to file afresh. So accordingly, the petition is disposed of on withdrawal with liberty to file afresh if so advised.
Please, Lordship. Lordship, I'd like to mention item number 3.
Admission.
Admission, Lordship. Lordship, I'm here to file my vakalatama, Lordship, on behalf of the respondent number 4. Even on the last occasion, we saw time to file our vakalatama, but we have come to learn that the respondent number 4 is in Gauhati for one of his children's medical treatment. So we are yet to get his signature. So if this matter can come up after 3 weeks, Lordship.
Your Lordship, I'm for the petitioner. On behalf of PB Chetri, we were instructed to take step upon respondent number 3 on last occasion.
You have taken.
May I please, Your Lordship? I have instruction to appear for respondent number 3. Kindly, if 3 weeks can be allowed
Okay, so
to file wakalanama and affidavit in opposition.
Learned counsel for the appellant, Miss Such and Such present. Learned counsel appearing for respondent number 4, Sri such and such, has submitted that he is yet to file the Vakalatnama as the respondent number 4 is out of station. And he has prayed for
3 weeks time.
3 weeks time to file his Vakalatnama and to file the affidavit in opposition if so advised. Stop prayers allowed. Learned Counsel, MS such and such has also entered appearance for respondent number 3 and prays for time to file her Vakalatnama and objections. So accordingly, list the matter of the 3 weeks.
Much obliged.
Much obliged, Your Lordship. Lordship, I would like to mention item number 4 on behalf of A. Sharma.
Okay,
Your Lordship, if this matter can be fixed on Monday.
Lordship,
Yes.
they are yet to file an amended petition. So if
okay.
matter can be taken up on Monday.
There was
since they
a
have
new
not-
implement.
Lordship.
Lordship,
For
we have
implement
already
and
taken
They are
this
yet
steps.
to file an amended.
So
But
will we,
after that, you have to file the
we'll
amended
be-
petition.
Yes.
Lordship, we'll be filing the affidavit today, Your Lordship.
Affidavit or the recast.
Yes.
I think it should be recast.
Yes.
Lordship.
Learned Counsel for the petitioner, MS such and such, prays for some time to file the recast petition in view of the new implement.
Yes.
In view of the new implement of respondent number
5.
5.
Respondent.
Stop. Prayers allowed. Mr. N. Angami appears for respondent number.
2 months.
Mr. V. Momi appears for
For.
respondent number 4.
Respondent.
4 and Mr. L.T. Sanctum appears for respondent number 3. This is the matter after a week.
Your Lordship, I was instructed to submit that there's some new development which has to be placed before this honorable court. There's some urgency, so it can.
Until unless they amend the petition.
You have to
Yes.
first place the amended petition before the court.
Yes.
Lordship.
So 1 week. So 1 week.
Obliged.
May it please Lordship. I beg to mention item 6 and 7, my lord.
Okay.
I've already in receipt of the affidavit in opposition filed by the respondent number 1. The pleading is completed, so let the matter come up after 2 weeks, after the summer vacation.
Okay. Learned Counsel for the respondent, you are for?
For the applicant in the IA, yes, 190 and 199.
Will come appearing for the applicant in IA 198 and 199. Submits that he has already received the affidavit
Affidavit in opposition.
position from the opposite
Respondent.
from the respondents. Accordingly, the pleadings are completed. List the matter after the summer vacation for, it can be listed for admission hearing.
Yes, yes, Lordship.
Listed for admission hearing after the summer vacation.
My lord, I also want to mention that since your lordship has rendered the decision in the MSCG in the main appeal, so it will be
Yes, yes,
proper.
then in
Will
that
please-
case, I won't be able to take it up. Then and
Yes.
list the matter before any other bench without me.
Yes. Much obliged.
Very please, Melody. For item number 5.
Hmm.
Melody, if we can take up the matter on Thursday, 26th.
Okay.
Your Lordship, I have some difficulty on Thursday. So if this matter can come up after the vacation, Your Lordship,
My lord, then what about Monday
no, next week.
next? Can we
After-
try today if that is, we can try
No,
today?
the
Since-
problem is we have to raise,
Yes,
raise by
That was
one.
my apprehension. That is
Yes.
why, actually, I'm also prepared for today, but then
Your
It's
Lordship,
got-
let the matter come up after the vacation.
Is there any urgency?
No, Your
It's-
Lordship,
there
this
is
is with
urgency
regard to
because-
posthumous regularization.
posthumous regularization and the petitioner is praying for pension benefits. So
That,
there's always an urgency in this kind of matters.
if at all the petition is allowed, you'll get everything retrospectively. So, list the matter after the summer vacation. No, first, no, delete that. Learned Counsel for the petitioner prays for listing the matter next week for hearing. However, learned government advocate AIMA has submitted that she has some difficulties. Accordingly, she prays for listing the matter after the summer vacation. Please for hearing after summer vacation.
17th. a fixed date may be given.
Okay, please for hearing on 17/7.
Obliged.
For motion from the supplementary cause list, item number 9.
Mileage.
Yes.
Well, this is a very simple matter. I am praying for setting aside of the discharge dismissal order. I sought discharge. It's a case of an under trial prisoner escaping from the jail. And simpliciter complaint was given. My lords can see the complaint. It is on page 50.
50.
50 minutes. In inviting reference to the subject cited above, FIR on escape report of one UTP from District Jail, Gauhati. I have the honor to inform you that one UTP, namely Tasatio Odiu, son of so-and-so, booked under so-and-so, has escaped around 5:20 AM from District Jail, Gauhati. Hence, you are requested to apprehend him and charge him with appropriate sections of law. This is for favor of so-and-so. Millets, the only thing reported is by the informant, which is a state itself, he's a state officer, is the escape of an under trial prisoner. The SHO in his wisdom received and registered in PS case number 44/90 on the margin, Millets, on the same page. SHO has recorded his endorsement under section 129, 128, 129 and 223 IPC. Millets, the FIR was to be required to be registered under section 224 IPC because that is what is reported. I don't know from where he got the idea at the stage of information itself that 128, 129 and 223, which are the offenses by the public servant having the custody of a prisoner of a state or prisoner of war, or being legally obliged to ensure the confinement of a prisoner of a state or prisoner of war. So 224 was not invoked, which is the ex facie evident from the complaint. And other sections were invoked. That is the first infirmity. And of course, in the course of investigation, Millets, police can add sections in the case diary and court may take name. So Millet, thereafter, investigation has taken place. The under trial prisoner was also apprehended from his home on the Christmas day. And he gave a statement that since co-accused in his case were given bail and he was not given, and he wanted to meet his son and family, etc. on the Christmas. So he was feeling lonely, so he just scaled the gates, main gate, and left. And he was arrested also by the police. So that is a separate issue, Millet. I'm not that because he is liable under 224. Millet, the first infirmity in this case, which is a very serious infirmity, I don't know to which court the charge sheet has been filed. The charge sheet, Millets, has to be filed with Ilaka Magistrate, and only thereafter
And you are Nimbemo Shitio.
yes, Millets. I am CTO plus 3 others. They all are jail warders. They are temporary employees. They have already been dismissed and then and there itself. So they are on the roads and they are on bail. So what I am saying, Millets, the procedure prescribed by the code is very clear. There are various stages. Code is a comprehensive code. My lords knows it. Starting from the constitution of the criminal courts and jurisdiction, and thereafter investigation, setting up the police station, appointment of SHO. So, Millets, section 190 of the code, which is now 210 of the BNSS, 190 says initiation of proceeding. Millets, no proceeding, criminal proceeding before a criminal court gets initiated unless the learned magistrate has taken cognizance of the offense reported to him. Some magistrate, if learned charge sheet is not submitted to Ilaka magistrate, then it has to be submitted to some other magistrate, and some other magistrate can also take cognizance and thereafter transfer it to jurisdictional magistrate. So, Millets, in this case, what has happened is no cognizance has been taken at any point of time, Millets. The charge sheet is filed sometimes after 15th of April 2024, because that is the date on which the deputy SP or some police officer has endorsed it. So obviously it can be filed only thereafter. So my lords, the first noting, we have taken the certified copy of the entire order sheet and we have filed it, my lords. It starts from page 60 onwards. And my lords can see my annexure R4. So I will draw my lords to page 61, which is the first order of the court. I mean, the court before which I am presently facing the charge sheet. I don't know where the charge sheet was filed, etc. So this is the first thing. Learned JMFC Civil Judge Junior. There it is filed. And my lords, on the 5th of September 2024, the orders of the court are: accused persons are absent, learned counsel is also absent, no service report received, reissue summons to all accused persons at the proper address to be present on the next date fixed, refixing so and so. So, my lords, straight away the accused are being summoned. That is not permissible in law, my lord. With due respect, the court has to take cognizance, because under section 190, learned magistrate has 3 kinds of jurisdiction available to him. He may take cognizance of the offense reported, summon the accused if the accused are named, and proceed with the further proceedings, which will 207, etc. onwards, and then charge. Second option is he may not take cognizance and discharge the accused straight away, as it happened in the case of this 2G scam, that CBI court just did not take the cognizance and discharge all the accused. And third is he may defer the process and ask for the further investigation, or he may ask for the clarification, etc. So learned magistrate is vested with the complete jurisdiction to make up judicial mind, either to proceed with the case, not to proceed with the case, or just to withhold the decision and ask the police to make further investigation. So, millets, unless that stage is over, section 190 is over, millets, we cannot come even 207. Certainly not to 239 at the stage.
This is the first order, 5924.
Yes, millets. 5924 millets, page 61. Millets, no reference of cognizance. This is the first order, millet. This is what from the file we have got. We don't know if there is some other file or I don't know, some other court, because we got no information from the file, court file, that where the charge sheet is filed and which learned magistrate has taken the cognizance. So I'm setting up the first issue itself, and that takes care of everything, millets. If no cognizance has been taken, case cannot proceed. And it is not curable, millets. We cannot go back in time. It's a criminal case, millets. And a lot of things have happened thereafter. So, millets, then subsequent orders are on 26/9/2024, accused persons,
But
namely.
basically you are on this.
Maintainability, millets. Maintainability of the criminal proceeding. No criminal proceeding can continue without cognizance, millets. Simple. It's a
Okay, who accepts notice?
right law, millet. Then there are other grounds also. So let my
At
learned
this stage,
colleague.
at this stage, we will only issue notice.
Yes, sir.
There are other grounds also, millet. So I leave it. I mean, maybe.
On this itself, notice can go.
Yes,
And
millets.
later we may-
But there are 2 more serious issues. Millet. Just I will take 1 minute.
Okay.
Second, millets, admittedly, the learned magistrate has admitted in the dismissal of discharge order itself that we were public servants. We were employed with the affairs of the state. We were jail warders. There are total 8 public servant accused. 3 are permanent, so they are still in service under suspension. We were temporary, so we have been terminated. That government can do. Now, millets, sanction under 197 for 3 have been taken. For us, no sanction also has been taken. Millet, 197 makes no distinction between permanent or temporary employee. It simply says employed for the affairs of the state or central government or state government. So, millets, I am employed, all 4 of me are employed for the affairs of the state government, that is performing duties in the jail, Bokha district jail.
No, but it depends on the terms of your appointment also. Because when in the appointment order,
My lords.
if it says ad hoc or temporary contingency,
Yes, ma'am.
and it says with 1 month's notice. Can
That
be
is for the, that's for
terminable.
the service side, millets. That is for my removal. 1 month note, my lords, is correct. I may be removed. See, millet, if I'm a permanent or regular employee, I can't be removed without any inquiry. But if I'm a contingent employee or if I'm a temporary employee, there are temporary service rules also which governs. Then I can be, my services can be terminated either with 1 month's notice or 1 month's salary in lieu of the notice. So that is Millards on the service side.
You're talking about the criminal proceeding.
I'm on criminal, Millards. I'm grateful, Millards. I just hit the bullseye. Millards, I'm saying you are admitting, the state is admitting that I am employed as a public servant. The state is accusing, in fact, Millards, if I'm not a public servant, then 128 and 129 and 2 to 3 will not apply. It applies strictly to the public servant suffering escape of a prisoner of war or prisoner of a state, etc. Public, exclusively public servant, Millards. The very fact that from the FIR itself, 129 and 128 and 2 to 3 have been pressed, and that is what the court proposes to frame the charge under, makes me a public servant. The court has admitted also, Millards. That is in the impugned order, court has admitted. Only thing court is saying that whether there was negligence on their part or not, that is matter of evidence. I bow down to that. But I am on different issue, Millards. I am saying, since I am public servant and court is admitting that I am a public servant, I cannot be prosecuted without the prior sanction of the state government. That is second point. And third, Millards, that takes everything away. Assuming, Millards, sanction is a curable mistake, Millards. I know the law. As an officer, I must inform the court that it's a curable mistake, error. The state can again take the sanction and come back. So that does not help me much. Point here is, Millards, assuming I ignore these two, cognizance also I'm ignoring because court has made up at some state to summon me. So that itself shows application of judicial might. But Millards, how the offense under section 129 and 2 to 3 is made? The prosecution has not consulted the Assam Prison Manual, which is adopted by the Nagaland, state of Nagaland. And I have enclosed Assam Prison Manual. Under section 91, the rules are to be framed. Rules have been framed. The duties of each of the jail staff, starting from the Home Secretary and coming down to the last person, there are 45 categories of that. I have enclosed that in annexures. Millards, jail warder has nothing to do with the custody or confinement. They are ministerial staff. Their duty is to keep the wards clean, hygienic, and see if a prisoner is falling ill or not. If a prisoner is found to be ill, they have to report to the jailer immediately. So they are not concerned with the custody. That is the job of the jailer and jail superintendent. So if at all police has found...
They were all warders.
Jail warders.
Jail warders.
Their duty is defined, Millards. Millards can just see for one moment. I have enclosed page 211, Millards. Onwards. It's slightly lengthy, but
The Assam jail manual, na?
Assam jail. No, I'm quoting the manual, Millards, yes, which Nagaland government has issued. And it has been published. Millards, it starts from Home Commissioner, page 214, Millards can come. The powers and duties of its officers and employees. So Home Commissioner of a state is the highest officer who is responsible for the jails, etc. That is serial number 1 and cadre strength 1. And Millards, jail warders are at serial number 16 on page number 215. This, Millards, may kindly note. Now there are 266 posts, and the duty given is warder is in charge of a ward or set of wards to see that the prisoners maintain cleanliness and also to examine the wards, cells of the prisoners, and to report immediately to the jailer of any sign of sickness or any prisoner complaining sickness. This is my duty, Millards. And if my lords consider the duty of jailer and jail superintendent, they are responsible for the custody of the prisoners. So, Millards, even if the under trial prisoner or any prisoner convict has escaped, jail warder cannot be held to be responsible for the escapement. There may be service lapses, Millards. That's a different issue. That remedy will lie in the service law domain. That they were negligent or not negligent. Point here is the criminal liability cannot be inflicted upon the jail warders with due respect, Millards, because my duty has nothing to do, because section 129, 128 and 2 to 3 are very clear. public servant having custody or having a legally obliged, that is 2 to 3, to keep in confinement. IPC. Or I have quoted in my petition also, but my lord can see the BRI, IPC. You have not got IPC. Let the court have it. We have quoted. We should always carry IPC in a criminal case. BNS. Let's can see section 129. Let's IPC. May I read? Public servant negligently suffering such prisoner to escape, that is the heading. Whoever being a public servant, I am a public servant, and having the custody of any state prisoner or prisoner of war, having the custody, that is the material issue. Nowhere in the FIR or in the charge sheet, there is even a whisper that any one of 4 of us had the custody of the escape UTP. That is 129. And 2 to 3 minutes, same. Whoever being a public servant legally bound as a public servant to keep in confinement any person charged with or convicted of any offense. So, Millets, I have been no legal obligation, no duty cast on me to keep in confinement. My job is to keep the wards clean, keep the prisoners in hygienic condition, and report any sign of sickness immediately to the jailer. So, Millets, even if the escapement has taken place, I cannot be held guilty of this. So, on merit also, Millets, even if technical objections are kept aside for the time being, though that they are available to me, Millets, no case is made out against me, and that's why I should have been discharged. And London Magistrate has fallen in error in dismissing my discharge application.
May I please, Your Lordship? Your Lordship, a record can be called for. However, Your Lordship, one thing to be considered is, Your Lordship, by learned counsel can make it clear before this honorable court as to how this revision has been preferred. Because it's apparent from the prayer of the petition that this revision has been preferred, challenging the order 35/2025. Your Lordship, annexure 1, page 46, Your Lordship.
The impugned order is page 46, 49.
My learned counsel is challenging this one, Your Lordship, impugning this one and coming before
Order of the JMFC.
GMFC. And what is how is this order come about, Your Lordship? Here the revisionists, they have actually filed this IA praying for discharge. And now the JMFC has ordered that like it's premature. Because if you can come to the operative portion, page 48, Your Lordship. Page 48.
Yes, I have considered.
Yeah, coming to this case at hand, it is not denied that accused so-and-so has escaped from the district jail, and it is also not denied that the accused so-and-so are government employed jail wardens. The question of whether the accused person were neglected in causing the UTP so-and-so escape the jail is a matter to be determined after leading evidence during the trial. At this stage, it would be too premature to come to conclusion that the accused person are not involved and discharge them. Your Lordship, after that, Your Lordship, the JMFC have fixed this matter on 31/7/2025 for CC, Your Lordship, consideration of charges. Your Lordship, my Lord counsel is coming before this court. The revisionists are coming before the court, challenging this order. I don't know what is wrong with this order, Your Lordship. If they are so agree with this order, they should go for appeal, Your Lordship.
Well, let's appeal with due respect to my learned.
The lapses that my learned counsel has raised, okay, that can be raised, but how?
The revision is against the order.
Yes.
Not allowing the discharge.
Yes.
Not allowing the discharge
Well,
application.
law on
Now,
this
whether that
issue,
can be,
I don't know if my learned colleague is invoking 3972, the previous thing, or 438(2). The law is that no revision shall lie against an interlocutory order. It's well said.
that I agree, Your Lordship. However, Your Lordship, even for.
But what she's objecting, if she can bear with me, if I've understood her correctly,
So you're saying that revision will not lie
No, Your Lordship,
against this order?
No, Your Lordship, my lordship, my petitioner is raising that cognizance has also not been taken. The matter is fixed on 31/7/2000 for consideration of charges also, your lordship. So now I find that there is nothing wrong actually. Record can be called for, your lordship, no doubt, your lordship, to ascertain, but
Of the state, I am unable to assist the court. Cognizance has not been taken, it cannot proceed further.
No, in what they're saying is, since cognizance was not taken, all these proceedings
I cannot even be
continue.
summoned. Everything is illegal.
yeah, that too, of course,
We'll have to see.
Yes.
That's why
Millets,
we'll
I
have
have-
to see the
I have-
reports.
I have quoted the Honorable Supreme Court judgment, Devinder Pal Singh Bhullar versus State of Punjab, where the Honorable Apex Court has very categorically said if the foundation is unlawful, everything done based on that foundation is also unlawful. So Millets, if cognizance is not taken, summoning is bad. The discharge dismissal order is bad. Direction to argue on charge is bad. It just cannot proceed beyond section 190. It has not proceeded in fact.
Heard Learned Counsel for the petitioner, petitioner/revisionist, Sri, your name?
I'm S.K. Srivastava with Mr. Lotha, NZ Lotha, my associate.
Yes, stop. This is an application under section 442 of the BNSS / section 401 CRPC. Praying for setting aside and quashing of the impugned order dated 30/5/2025 passed by the learned Judicial Magistrate First Class Wokha in GR number 74/2019, under section 128/129/223 of IPC.
224 is also there, but I'm not concerned, Millets. That is not against me. That is against the escaped prisoner.
So yours is only.
Yeah, only 129 and 223 Millets. 128 state itself has dropped. So I'm not pressing.
By the impugned order dated 30/5/2025, the learned JMFC Wokha had
Page 46 onwards Millets.
Touch 46, annexure 1.
Yes.
But material part is on page 48, last but one para from bottom.
Had dismissed the IA filed by the petitioners herein, praying for their discharge from the case. So the petition has been filed on the ground that no cognizance has been taken by the magistrate before issuing the summons to the present petitioners. Stop.
Cognizance of offense Millets. because
Cognizance of the
Offense, that will be appropriate Millets. We do. I'm
It's
grateful.
understood when you say cognizance of the offense has been taken, then that will be small number 1. Then number 2, that no prosecution sanction was sought for the present petitioners.
Nor given Millets.
Sought or not given?
Not given. I don't know whether they sought or not. We don't know.
know.
We don't know Millets.
So
That is for them
that
to.
Just say no prosecution sanction was given before the proceedings. were
But
initiated.
submitted before the learned magistrate Millets. That will be more appropriate. Because it is their responsibility to produce the prosecution.
Prayer,
I'm
it's
just
a
stating your
prayer.
ground.
My lord,
Just stating your
I vote
ground.
up.
Yes.
My apology Millets.
Stop. Number 3, that the duty of the warder is not the custody of the UTP or convict, but and therefore that they are not responsible for the custody of the escaped UTP. Stop. Next para. Learned PP Livica accepts notice on behalf of the state respondents, and therefore no formal notice is called for. Stop. Issue notice returnable within 4 weeks. Call for the scanned copy of trial court records. Any interim prayer?
My lords, because the whole thing will become
Lord.
infectious if my lord do not protect me. Because it will become
Lord.
fait accompli. So my lords can say that deferred, the hearing on charge should be deferred.
Interim, it is directed that the hearing on the framing of charge.
Your lordship, framing of the matter is fixed on 31/7, your lordship. So let this matter be posted before 31, and before 31,
My
nothing
lords,
can
or my
happen.
lords, may I suggest?
Meantime, let the record come
This is
and we
what
will
is
decide,
regularly
your
done
lordship.
by Honorable Delhi High Court and Supreme Court also. The Honorable High Court says that trial court may fix their date after the date of this Honorable Court. So that takes care of everybody's concern.
It is already on 31 September.
31st,
So the
31st.
matter can be-
So either my lords can have
One-
what my elder sister is saying, my lords can have date before that, but that
before
will be
that, yes.
before that.
Ah.
So no issue. I
So
mean,
on that day, you cannot
Yes.
express again.
Yes.
or
Yes.
my lords can say one line because it becomes a stale, then they will say that it was not given in the first hearing.
Then
My lord
interim
can
be-
just say-
interim can be
My lords, let them, I don't
You
mind.
will just say the interim will be considered
on the next date. Yes. Your
All
Lord.
right, my lords, that's okay. And my lords can give me a date then before 31st, subject to
So,
my diary
so
minutes.
after 4 weeks, give a date after 4 weeks from today. Today is 20th, so
No, she's giving date.
21st July.
No, I come from Delhi, so not Gauhati only. They just,
Twen-
24 CBI in Gauhati, no? So let me see if,
Either 21st or 22nd.
just. My lords, I have a heavy board in 22nd, my lord, because I am appearing before various high courts. 24, I have cases in CBI court, Gauhati. And maybe 25th,
25th then, 25th July.
it is for you only. Right? So, Kohima only. So 25th July, my lords,
25th.
I am grateful,
25th.
grateful, my lords.
Much obliged.
For admission from the supplementary cost list, item numbers 10 to 12.
May I please, your lordship?
Yes.
I was watching the earlier matter. It was a very persuasive argument from both the sides. Even my lord was also very persuasive. My lord, before we go into the matter, I would like to bring certain facts for your kind consideration.
My
As
lord,
per sir,
maybe
please,
lordship,
let me
yes.
make my submission, please, sir.
one second. I want to
Sure.
make mention.
Yes.
I'm yet to receive the updated CD. So my lord,
Ah.
let the matter fix on Thursday, and on that the matter can be disposed of, my lord.
No. I want to clarify certain points.
Without the updated CD, this court cannot pass any order.
Yeah.
No, my lord, absolutely. I want to bring two things which your lordship should record it in the order. Is that
No,
against
we'll
the
just adjourn it. We'll just adjourn it to Thursday.
Yes,
no, my
yes,
lord,
26.
kindly bear with me for a one moment.
Yes.
Wait with one moment, so that it will be recorded. Because on the last occasion, I apprised this honorable court that I have preferred the SLP. Now, on 16th of July 2025, my prayer in the SLP was granted. Accordingly, I appeared before the IO on 17th of July 2025, where I gave my statement. These are two things. Third is your lordship will kindly come to the order, impugned order passed by the High Court at para 6. Order dated 29 May 2025.
Why do we have to go into this? now?
Yes, my lord, I will apprise this court that why it is so sacrosanct at this point. Kindly come to para 6.
Page.
No, it is the order of the High Court, 29th May 2025, which was been
Order of this court.
yes, which was been interpreted by the Supreme Court. My lord,
29
kindly see para 6. Para 6.
Yes.
Yes, my lord is there. I'm just taking it for a moment. He further submitted that upon learning about the lodging of the FIR, the petitioner immediately applied for a certified copy of the FIR, the copy of the case bail register, and a letter from the High Court, which was received by the current Principal District Judge Dimapur, the informant in this case. According to the FIR, the current Principal District Judge lost the FIR under the direction of the High Court, but only a copy of the FIR was supplied to the petitioner. Other two documents were not provided. Thus, the petitioner is unable to ascertain the contents of the High Court's direction based on which the FIR was lost by the Principal District Judge Dimapur. Now, accordingly, I have annexed that certified copy application form, which is at Annexure P4. So, what I am requesting this honorable court is that, of course, my lord will call for the updated case diary. I've got no issue on that. But at least provide me an opportunity so that I can collect that document. Because this is not under, these proceedings are not under PMLA, that it will be kept holded like ECIR. It's a public document.
So why the document was not provided to me?
You asked for it, I'm sure.
No,
you-
it was not been provided, my lord. It was not been provided. Kindly see my annexure P4 in my bail petition. Annexure P4. FIR copy West PS case number 40 of 2025, copy of cash bail register and letter from High Court. So I must have the letter from High Court.
So what about this number 2? You got number 2?
No, I have not got anything. Only the copy of the FIR.
FIR.
So let the court direct me. Let the court direct me that this order so that I can present it before the CAGM and get the copy.
Okay. Learned counsel for the petitioner, Mr. S. Borgohain is present. Stop. He has submitted that the petitioner has not been supplied with a copy of the cash bail register and the letter from the High Court, which are allegedly on the basis of which the FIR has been registered. And he has prayed that the direction may be given to supply him a copy of these documents. Stop. At this juncture, the learned public prosecutor, Mr. Tiba Pom, has prayed for some time as he is yet to receive a copy of the updated case diary. Stop. Accordingly, list the matter on
26, my lord. Trustee.
My lord, I will be on 26. It will be difficult for me. 26 will be difficult because any date after 30, any date after 30.
We are on vacation from 30 to 14th.
Well, let it come after vacation. Let it come after vacation so that we can all have interaction with the IO and everything. We will let it be reflected in the order sheet.
Okay, my lord.
So accordingly, list the matter on 15th.
Well, let it be on 16. Let it be on 16.
July.
16 is Wednesday, my lord.
Oh yes, 16 is a Wednesday. The division
17.
bench.
Yes.
17.
On 17 July for admission.
For the hearing, my lord.
Hearing, stop. In the meantime, the
CGM, my lord, CGM.
CGM, Dimapur, is directed to supply copies of the what is
Document mentioned in my certified copy.
No, wait. We have to specify copy of the cash bail register and the letter from the High Court on the basis of which the FIR was lodged to the petitioner.
My Supreme Court grant bail, that order I could not be furnished to you at this moment. I have applied for the certified copy. Let it be recorded.
Is also submitted by the learned counsel for the petitioner that the Honorable Supreme Court.
White order dated 16/6/2025.
6/2025 has granted interim pre-arrest bail to the present petitioner, a copy of which shall be furnished by the petitioner during when can you furnish?
My lord, today I'm going to get the certified copy. Today I'm going to get it. Monday I can do it.
1 week, within a period of 1 week.
Yes.
Much obliged.
Obliged, Your Worship.